once again formally welcome to our regular Forvm Romanvm meeting. And I would like to give the word to Valentina to introduce our guest.
I would like to thank to our dear guest, Professor Tommaso Beggio. He is professor at the University of Trento, and he teaches a lot of courses because at the University of Trento there are a lot of courses of Roman law. For example, there is a course of Roman criminal law, which is for us here a little bit unknown. Not a little bit, but we can say completely unknown, because at the University of Belgrade, and not only at the University of Belgrade, in all universities in Serbia, there is only one course which is called Roman law or Roman private law. So we are focused on the Roman private law, and we are, I suppose, all of us, we are very curious to find out how it, at least how it looked like in ancient Rome. This sentence, which is concerning the gravity of the sanction, the most dangerous sanction. So I would like to once again to repeat the title. It is Capital Punishment in Rome, ancient Rome. So I suppose it will deal with the sentence to death. So dear Tommaso, I will give you a word. Once again, thank you a lot because you find the time to join us, and we hope that we will see you in Belgrade when we start our meetings di personas, if I say, in presenza, yes.
Okay, so thank you very much. I would like to thank Professor Valentina Cvekovic for the kind invitation, and I would like to thank the people who have organized this meeting. I'm really honored to be here, and not to be there, of course, but I'm really honored to have the opportunity to give a presentation at the Forvm Romanvm, and thank you one and all to attend my presentation. So my presentation will focus on the so-called capital punishment or capital punishments in ancient Rome. And this is a question that has to do, first of all, with the term capital punishment, in the sense that we nowadays mean or think of capital punishment as death penalty, mainly as death penalty. But it was not that simple in ancient Rome. And so I'll try to offer you a brief overview, historical overview of the development of capital punishment, and then I'll focus on some sources of the time of the Principatus, just to underline some features of capital punishment at the time of the Principatus, so from Augustus onwards. So the development of capital punishment could be considered as one of the most important examples of the influence of cultural, religious, and political values. And the evolution or the concept of capital punishment was somehow based on the idea of the separation of the guilty person from the rest of the society in ancient Rome. So the concept of capital punishment represents a sort of paradigm of the development of the Roman repressive system according to the social, cultural, and religious conditions that influenced the Roman repressive system in different points in time. In particular, the need to separate the guilty person from the rest of the society was mainly due to religious and cultural reasons in ancient Rome, as the Pax Deorum, the peace between the community and its gods, had to be preserved. The punishment of the guilty person represented something different, of course, during the age of the Principate, and then later at the time of the Dominatus, because at that point, capital punishment became the main manifestation of the repressive power and the control of political power on the public sphere of the society. So far from being just the application of the death penalty, capital punishment in ancient Rome was the result of a long cultural, legal, and political reflection on the status of the convicted person that had to go through a permutatio, through a deep modification of that status. This modification affected the caput, meaning by this term both the body of the person, the head, and the person, the legal position of the person within the social community. This concept evolved in many ways over the centuries, as I told you before, from the archaic period to the age of the Dominate, but capital punishment always essentially represented the means used by Roman power to separate the guilty person from the rest of the community, depriving him of his social and juridical status. Capital punishment represented the manifestation of the exercise of the right to let live and to kill, in particular in the archaic period, so in archaic Rome at the time of the Republic. And this power to let live and to kill was used by the public authority to preserve itself and to preserve the community when rules had been violated. And we can, of course, observe this kind of absolute power to kill or instead to let live already in the private power. And so in the Institute of the Patria Potestas, that was typical of archaic Rome and was connected to the so-called vitae necisque potestas. That is exactly the power to let live or to kill. This kind of power was distant by the power of private people over the time, and this power to let live and to kill became the manifestation of the public power to punish, and it began to involve not anymore only the person in his existence, but also the person as a member of the social reality. This conception went through a powerful evolution during the age of the Principate, when the guilty person could be subjected to a particular legal regime known as servitus pene, so slavery of punishment. The slave of the punishment, the servus pene or the serva pene, lost the libertas and became legally subjugated to the punishment. So it has been correctly said by many scholars that in ancient Rome during the age of the kings, the exercise of repressive power was at some point institutionalized for the first time, and the intervention of public power represented the means to prevent private revenge between social groups and families. This intervention has also had another essential meaning. It was necessary to restore the pax deorum, and so the harmony between the gods and the community. And three different kinds of punishments developed in ancient Rome. Well, one of these was not exactly punishment, but let's have a look at them. So the sacertas, and so the homo sacer. The sacertas was a kind of death penalty, but was not exactly like the death penalty. And then there was the death penalty, that was the so-called pena capitis, so the pena concerning affecting the caput, the head of the person, and then the exile. And the exile was known as exile, and then later on as aqua et igni interdictio. And even if these three punishments represented different ways of punishing the convicted, all three penalties were connected to the problem of the relationship between the gods and the community. And in particular, the case of the Sacertas was connected to the problem of the need to expel from the community of people the convicted, the homo sacer. And the homo sacer was so called because he was somehow devoted to the gods, and everyone could kill this homo sacer if he decided to come back to Rome. So he was expelled from Rome, and if he decided to come back to Rome, he could be killed. So it was not like the death penalty, it was something different, because the man, the body, and the person were devoted to the gods. And so this legitimized the possibility for the other people of the community to kill this person if this person came back to the city of Rome. The other punishment, the death penalty. So the death penalty was not particularly frequently applied in the history of Republican Rome. And so it began to be more and more frequently applied at the time of the Principatus. And the main way, so the most common kind of death penalty was the beheading at the time of the Republic, with some exceptions. So the exceptions of some, we could define them as expiatory rites, like throwing the convicted from the rupe Tarpea, so from the cliff Tarpea, or tying the condemned in a bag together with animals and throwing the bag into the Tiber River, so the pena culle. But these kind of punishments were connected to expiatory rites. Otherwise, the main way to give the death to the convicted person was beheading. Consisted in beheading the convicted person. As I told you, there was a third kind of punishment, but it was not exactly like a punishment. This third option, if we can call it an option, was the voluntary exile. So this was an alternative to the death penalty. Roman citizens could save their lives and so escape from death, but they had to exile themselves from the society. This kind of alternative to death penalty was not a punishment itself, or at least the exile, the voluntary exile, was not a punishment itself, at least until the time of Sulla. Because under Sulla, a lex was enacted, the Lex Cornelia de Majestate, and through the enactment of this lex, it was recognized that the exile by the name of aqua aetinia interdictio could represent a punishment in itself. So there were two different kinds of exiles after the time of Sulla. The voluntary exile as a way, as a means to escape from death, and the aqua aetinia interdictio as a proper punishment. And the effect of the aqua aetinia interdictio after the time of Sulla consisted in depriving the convicted person of citizenship. We can argue that these effects already existed before the time of Cicero, because when Cicero enacted the Lex Tullia de Ambitu, so concerning the crime of election, political roughing, political rigging, Cicero decided to punish the people who committed this kind of crime by inflicting them the exile, but in the sense of the aqua aetinia interdictio. So the effect was the loss of citizenship and part of their patrimony. But in any case, so these two kinds of punishment, the death penalty and the exile, both the voluntary exile and the aqua aetinia interdictio, remained the most important capital punishments at the time of the end of the Republic, and so till the time of Augustus, till the age of Augustus. So during the last century of the Roman Republic, something paradoxical happened in the sense that while on the one hand there was an attempt to define both the typologies of the different crimes and the rules of the criminal procedure through the institutionalization of the so-called questiones perpetuae, a kind of permanent tribunal, permanent court. On the other hand, there was a permanent struggle for power to lead either to an abuse that led to either an abuse of coercive power or to the use of illegal means that were substitutes for the recourse to capital punishment. So the point is that at the end of the Republic, there was no legal thinking, and the same jurists did not try to make a huge effort to organize the two different kinds of capital punishments and to give them a sort of systematic order, even if it's always difficult to talk of a system when we are dealing with the Roman jurists, of course. But we could simply admit that at the end of the Republic, there were these two kinds of capital punishments. The main effects were either the death of the convicted in the case of the death penalty, or the loss of the citizenship in the case of the aqua et interdictio. Yet, of course, something changed from the time of Augustus onwards, because according to the majority of scholars, from the beginning of the Principate, the Roman political repressive system underwent strong institutionalization, and new uniform rules, thanks to the leges Iulia Judiciorum, were established, and in particular with new rules were established, in particular with regard to the punishments and procedures in the city of Rome and in the rest of the new empire. And this is a very traditional opinion that dogmatically depicts a supposedly coherent and rational evolution of the Roman repressive system. But we actually know nowadays that it was not exactly like that. So the evolution of the system was not so easy at the time of Augustus and later on. In particular, the same idea of pena capitis underwent a new kind of development. But first of all, I would like to underline a passage. So the fact that in ancient Rome and at the beginning of the Republic, it was usual to define this kind of punishment as pena capitis or pena capitalis. These two syntagmas were conceived as equivalent. So it was possible to define the capital punishment and the death penalty as pena capitis or pena capitalis. Something different began to emerge at the time of the Principatus, at the time of the Principate. So, sorry. It's the advice of the faculty. It's usual, so it's nothing weird. So I just forgot that there is this advice every day. So I was saying that pena capitis and pena capitalis had more or less the same meaning at the time in archaic Rome and at the time of the Republic, but something changed at the time of the Principatus, because whereas the pena capitis began to define the proper death penalty and the so-called summa supplicia, on the other hand, the pena capitalis began to define the kind of punishments that led to some legal effects consisting of either the loss of citizenship or the loss of liberty, or in the end, eventually the death of the convicted person. So the idea of pena capitis as a punishment that deeply affected the body of the convicted was also somehow strengthened after the last period of the Republic. During the age of Augustus, new forms of punishments began to emerge, such as the deportation to an island, that affected, of course, the convicted person who lost part of his patrimony and lost citizenship. The development proceeded under Tiberius and later, and the number of new capital punishments increased dramatically. Some of them caused the immediate death of the condemned. It was the case, for example, of the plumbatio, that is, pouring molten lead down the throat, or it was the case of the crucifixion, or some other kind of so-called summa supplicia, so the most severe, harsh punishment known in ancient Rome, whereas some other punishment did not cause immediate death, though yet death might well follow. This is the case of the condemnation to forced labor in the mines, or the condemnation to fight as a gladiator. The first one, known as damnatio ad metalla, generally speaking, but there were different kinds of damnationes ad metalla. The second one, known as damnatio ad ludum, generally speaking. So there were also punishment that has as their objective the expulsion of the convicted from society. This was the case of the deportatio that I already mentioned before. And in many cases, anyway, coercive power affected the body of the convicted. And the criminal repression in this case was not meant as a way to satisfy the demand of harmony between the community and the gods, of course, but it began to represent, the expression of the absolute power of the emperor and the imperial reaction against any behavior that could treat an imperial authority. It is, for example, no coincidence that the sentences, the judgments for the crime of maiestas markedly increased. And so it began to emerge a dichotomy. At the time of the Principate, it began to emerge a dichotomy between punishments causing the loss of citizenship, known and defined by the Roman jurists as peregrinitas, the loss of citizenship, peregrinitas, and punishments causing the loss of freedom and eventually, but not necessarily, life. And these cases, these kinds of punishments were included in the group of the so-called servitus pene, slavery of punishment. So there are also sources, of course, that show us that one punishment, one capital punishment, might be preferred to another according to local customs or social needs or for religious reasons. For example, being condemned to fight as a gladiator, simply to fight as a gladiator, this was the damnatio ad ludum or ad ludos. That was something different from the damnatio ad gladium. So this kind of condemnation, the condemnation to fight as a gladiator, was still one of the most frequently applied condemnation, for example, in Gauls during the 2nd century, 3rd century AD. Well, because of course the gladiatorial shows, munera gladiatorial, were particularly popular at that time in the western part of the empire. But of course, as I told you before, the choice between one punishment or another could depend also on this kind of local custom or social needs or economic reasons, for example, because sometimes the condemnation to forced labor in the mines was preferred to other kind of punishments because it was, of course, a means to get people working in the imperial mines. But in any case, one element constantly emerges, that is that the punishment at that point of at that time represents the power of the emperor, and this power exercises its strength through the body of the convicted. Capital punishment thus assumes both a retributive and preventive function, and capital punishment goes through a kind of spectacularization in some cases, as in the case of the condemnation to fight as a gladiator, or a living representation of a condition similar to death. That is the condition of the people condemned to work in the mines for the rest of their life. Sometimes the punishment could signify both spectacularization, and the death of the convicted, as in the case of the condemnation to beasts, or as in the case of crucifixion, or again in the case of the damnatio ad gladium. That was quite similar to the damnatio ad ludum, but it was not the same, because the damnatio ad gladium consisted in a condemnation to fight as a gladiator, but then the convicted person had to be killed, had to be beheaded within a year from the judgment had been delivered, if he did not die, of course, during the gladiatorial fights. Of course, then the strong influence of religion in Roman criminal law is evident in the age of Constantine, when Christianity began to play an essential role in the empire. And of course, according to an Iranic interpretation of this religion, the majority of scholars in the past had too often reduced criminal law in the late antiquity to a sort of Roman Christian law, in which religion simply introduced some new kinds of crimes, but at the same time more humanity into the repressive system. We can, however, infer from the sources of that time that Christianity brought no warranties in the process or in the execution, but rather criminal legislation in general developed a strong identification of crime with sin. And so new kind of punishments, for example, were introduced, and capital punishments were often prescribed for crimes previously punished by less serious punishments. But this kind of development had to do with the kind of development of the imperial power as well, of course. But so what we can therefore affirm is that at the end of the Republic, the syntagmas pena capitis and pena capitalis were equivalent, and as I told you before, they had to do with the suppression, elimination of the caput of the convicted person, or in some cases, in the case of the Aquatini interdictio, with the loss of citizenship for the convicted person. So in some way, at the end of the Republic, began to emerge a sort of binary system based on the idea of the death penalty and the loss of citizenship. But of course, as I told you before, Roman jurists did not focus too much on this kind of evolution, this kind of development, and for many different reasons. So, as I told you before, as I already mentioned, from the sources that we know, we can argue that the death penalty was not often applied at the time of the Republic, at least until the end of the Republic first. And usually the death penalty was immediately executed. So after the final definitive judgment had been delivered, the convicted person was executed. And the case of the Aquatini interdictio as a means, as a punishment that led to the loss of citizenship was quite limited. So the use of this kind of punishment was quite limited, and sometimes at times it was used only for political purposes. This kind of binary system, in any case, had a reflection on the system that developed at the time of the Principatus. And we can argue argue that something happened at the time of the Principatus thanks to the legal reasoning of the Roman jurists on the problem of the capital punishment. This is the point on which I would like to focus now. So, well, I wrote down many sources, and it was possible, of course, to quote many others, but I decided to make a selection of them. There is the English translation. It's the English translation by Watson. I don't find it always correct at all, but in any case, I think that many passages are fine, are okay. And well, the first interesting text that I decided to select is the first one by Paulus, and Paulus is here writing a comment on the Edict of the Praetor, Digest 48.1.2, and it is quite interesting to have a look at the definition of publicorum publica judicia, that is capital criminal proceedings. Capital proceedings are those where the penalty is death or exile, which here means interdiction from fire and water, because by these penalties civil status is taken away. That is what I said before. That is the description of the capital punishment as intended, as meant at the time of the Republic. So Paul is, in this case, writing down this comment because he's commenting on the Edict of the Praetor. Whereas it's maybe more interesting for us to have a look at the second text, that is the text by Callistratus. So Callistratus, at the time of the Severan dynasty, wrote the work, his work, De Cognitionibus, on De Cognitiones Extra Ordinem, on this kind of legal procedure, and the sixth book is devoted to the criminal legal procedure of De Cognitiones Extra Ordinem, and Callistratus decided to open his treaty with his work with a description of the capital punishments. This is one of the most important definitions that we find in the digest concerning the capital punishments. The list of capital punishment is not complete because some capital punishments are not mentioned by Callistratus, but nonetheless, the text is particularly important to us. So, capitalium penarum fere isti gradus sunt, so the stages of capital punishment are more or less as follows. The extreme penalty, so summa supplicia is the first category mentioned by Callistratus, summa supplicia, the extreme penalty is held to be condemnation to, within brackets, I wrote down gallows, whereas Watson wrote cross. The point is that in Callistratus, we read ad furcam damnatio. And so the right translation would be condemnation to the gallows. Yet Watson was right in writing down crux, because in this case we find an interpolation in the text of Callistratus. If we compare the text of Callistratus with a text that we found in the Pauli Sententiae, in particular 5:17.2 in the Pauli Sententiae, we see that in the Pauli Sententiae, the capital punishment that is mentioned is exactly the damnatio ad crucem, so the crux. But of course, this is an interpolation that took place after the abolition of the crux, after the abolition of the damnatio ad crucem and the late empire. So then there is also burning alive, that is another summum supplicium. This, however, though deservedly included in the term extreme penalty, is yet regarded as following after the first. And also there is beheading. So as we can easily understand from the text of Callistratus, at the time of the Principatus, at the time of the Principate, there were many different kinds, many different ways to give death to the convicted people. The summa supplicia were the harsh punishment that could be inflicted to the convicted people, to the convicted person. Still, it was possible to give death to the convicted person by beheading the convicted person, idem capitis amputatio. And then it's very interesting because there is the proxima morti pena metalli coercitio. This is the damnatio ad metalla. So this is the condemnation, of course, to forced labor in the mines. That is particularly harsh, but of course, in this case, the convicted was deprived of her liberty, her freedom, not of his life. of course, the convicted could eventually die because the conditions of life were terrible, were absolutely bad, terrible, incredibly harsh. Yet, the point is that a capital punishment could be a punishment that deprives the convicted person of the freedom. Then post deinde, oh sorry, deinde, not deine, of course, it's another typo, I'm really sorry. Post deinde in insulam deportatio. And again, Callistratus mentions here the deportation to an island. That is a kind of punishment that deprives the convicted person of citizenship. That is to say, we have now, under the name capital punishments, we have now three different groups of punishments. The punishments that lead to the death of the convicted person, the punishments that deprive the person of freedom, the punishment that deprive the convicted person of citizenship. And this is the most important evolution through which underwent the capital punishment at the time of the Principate. And I find very important and very interesting that a Roman jurist tried to systematically depict this situation as Callistratus did. Still, very important for this brief overview, sorry, we find other kinds of punishments, for example, in the text that is Ulpianus 10 ad Sabinum, Digest 28366E, under E. But even if someone has been condemned to capital punishment, and in this passage, in this text, another kind of summum supplicium is mentioned, to fight with bis, that is the damnatio ad pestis. So to capital punishment, to fight with bis, or to be beheaded, or condemned to another punishment which deprives him of life, his testament, and so on and so forth. So once again, the main effects of capital punishments are depriving a person of life, either life or freedom or citizenship. But here is an important distinction. Here, an important distinction emerges. If the punishment deprives the convicted person either of life or freedom, in this case, according to the definition of the Roman jurist and the imperial chancery, this person will be a servus bene. So this person will be subjugated to his own punishment. So, and then we can have a similar description, for example, in the case of the text under F by Callistratus, once again, from the first book, De Cognitionibus. In this case, Callistratus focuses on the idea of status. But as I told you before, the status permutatio was at the basis of the capital punishment, in particular at the time of the Principate. Status is a position of unimpaired standing, which is established by law and custom, and under the authority of the laws may be reduced or removed by our delete. Status is reduced if we are assigned a penalty which affects our standing, although liberty remains, as for instance, if someone is banished or removed from the order or debarred from holding public office, or if a plebeian is beaten with prods or assigned to public labor. In Watson's translation, there is forced labor, but this is public labor. This is opus publicum, that is something completely different from the forced labor in the mines. So I thought it was better to distinguish these two different kinds of punishments, or if anyone falls under any heading which is listed in the perpetual edict as bringing infamy. Status is removed if magna maxima capitis diminutio, so that is the status permutatio maxima occurs. That if the privation of liberty occurs, as for instance, if someone is forbidden fire and water, that is the old aquatini interditio, which occurs when is deported, or if a plebeian is assigned to forced labor to mine work. And as I mentioned, they're either opus metalli or metalla, because there were different grades of damnationes, of condemnations to forced labor in the mines. The harshest was the damnatio ad metalla. In the middle, we find the opus metalli, and then at the bottom, the ministerium metallicum. For it makes no difference, nor is there any distinction between opus metalli and metalla, except that those who escape from opus metalli are punished not by death, but by assignment to metalla. And again, in the text by Modestinus and G, 8th book Regularum, Digest 5016 103, dicet capitalis latine eloquentibus omnis causa existimationis videatur tamen appellatio capitalis mortis vela missionis civitatis intellegenda est. That is to say, although for as the translation says, although for those who speak Latin capital covers every case where a man's reputation is at stake, nonetheless the designation capital is to be regarded as covering death or loss of citizenship. And it's quite weird that in this case, Modestinus does not mention the case of the loss of freedom. There have been many explanations to this lacuna, to this gap in Modestinus' text. One of these is that the text has been interpolated. That is absolutely possible. Another possibility actually is that Modestinus just wanted to stress that also the loss of citizenship was enough to have capital punishment, and if the loss of citizenship was enough, a fortiori, so far it's clear that so the loss of freedom too would have led to the regime of the capital punishment. And another important text I would like to quickly focus on, because I suppose that my time is running out, by the way, so I'm really sorry, because there are so many things to say about this topic, but I'll try to quickly conclude my observations, my remarks. In any case, another text I would like to quickly read is the text under C. Macer. So again, a jurist of the time, the Severan dynasty, who wrote, so far as the status of the condemned is concerned, it makes no difference whether the trial is public, judicium publicum, or not, so cognitiones extra ordine. For regard is paid solely to the sentence, not to the nature of the charge. Therefore, those ordered to execution or who are given to the beast forthwith become servi pene. That is to say that certain effects, certain legal consequences depend on the kind of judgment, and the judgment, of course, contains, in this sense, the punishment. So certain circumstances, certain effects, legal effects, depend on the punishment. I just want to maybe for a second conclude with the may I close my file? Sorry, okay, sorry, it worked. So what we can argue from the text of the jurists of the 2nd and 3rd century AD, in particular, from the jurists of the Severan dynasty, of the age of the Severan dynasty in particular, is the fact that there has been an effort made by the jurists to try to put order and the situation concerning capital punishments that was hugely complicated at the time of the 2nd, 3rd century AD. Why? Because many other kinds of punishments over the decades developed. So not only at that time, there was not only the death penalty or the acquitting interdictio. So it was necessary to try to put order, to give a sort of systematic order to these kind of punishments in order to understand what the effects, legal consequences of these punishments were. And in this way, the jurists, of course, the imperial chancery on the one hand and the jurists on the other hand, tried to focus on the main effects of capital punishments. That is to say, capital punishments could give death to the convicted person, could lead to the loss of freedom, or could lead to the loss of citizenship. And what the jurists did was trying to group the first two kinds of punishments that led to the death of the convicted or to the loss of freedom into the servitus pene, and the servi pene were slaves subjugated to their legal status as a consequence of a sentence that deprived them of their freedom and, of course, at times of their lives. But what emerges from the text of Macer is that at some point, the effect of the loss of freedom was not any longer necessary to have a capital punishment and a capital judgment, because the nature, capital or not capital, depended on the kind of punishments. So, damnatio ad metalla, either at tempus, so either for a limited period of time, or in perpetuum, so for the life of the convicted, I just make an example, in the 3rd century AD led in any case to a capital punishment and led to the servitus pene. Servitus pene consisted again in a subjugation to the punishment, and even if person became a servus pene for 10 years, it was not possible any longer to have back freedom for the convicted person. And so the servus pene became a servus nullius after the end of the condemnation of the punishment, if the punishment was limited in time. So if the time the punishment was limited. So what we can infer from the text of Roman jurists is that there was a huge development concerning the idea of capital punishment, even if, of course, there are many exceptions concerning, for example, local customs and the application of law in the provinces and so on and so forth. So I don't want to have a too much dogmatic approach to this topic, but in any case, there was an effort made by Roman jurists to try to depict a legal institution that was the institution of servitus pene, that represented a development of the ancient capital punishment, and that grouped all so many kinds of punishments all together. All these punishments led to some specific legal consequences and effects. On the other hand, what was not included in the servitus pene were the punishments that led to the loss of citizenship, like, for example, the deportatio. In this case, the convicted people were subjugated to the legal regime of the peregrinitas that led to the loss of citizenship and part of their patrimony, of course. But they were not servi, and of course not servi pene. So I think I've finished my quick, very, very brief explanation, because I know that the topic is huge, and there are many texts that should be analyzed in order to better understand the problems concerning the development of capital punishment at the time of the Principatus. But I finish here with my presentation, and so thank you very much for your patience.
Thank you very much, Professor Beggio. This was a very interesting lecture. And now I'm opening the discussion, and Valentina has already raised a hand. Valentina, you're muted.
Yes, I understood. Dear Tommaso, thank you very much. It was very useful for all of us to hear something new. As I said, we are not acquainted with the Roman criminal law, so this topic is even nowadays very actual, and in terms of capital punishment, we are faced with this question very often, also in media. When somebody committed very severe crime, does it deserve a capital punishment or not? So I would like to say that the problem of sanctioning the crime is something which is very actual through all those centuries. So we can observe your conclusion not only in terms of ancient Rome, but also in terms of modern law. The second, which I want to ask you, and which I read in your book, I would like also to recommend to our participants. There is a book, and I'm very grateful because Tommaso sent me this book. The title is Contributo allo studio della servitus pene. And you in this book I just began to read, so I didn't finish. I haven't finished yet. You mentioned this problem of servi publici, servi pene, servi Caesari. So could you tell us briefly what is the main problem? Because you also mentioned that the great scholar Theodor Mommsen had his own theory concerning that. And I would like to ask you to explain briefly, of course, what is the problem and what is the difference between these three categories of slaves.
Okay, so thank you very much, Valentina, for your questions. And well, with regard to your first remark, observation, I would say, yeah, that it's still very debated, the problem of death penalty. Still, so sometimes ancient Roman law comes back like the duck of Goethe, as usual. And what I would like to underline, to stress with regard to what you said, is that from the sources, from Roman law sources, and in particular from the text of the jurists, we can learn that they tried, in any case, to develop a lot of principles. Of course, they did not create principles. They did not write down principles because it was they did not like to do it. It was not their method. But still, if we read the text, for example, there is the problem of the graduation, the different stages of the punishment according to the circumstances of the crime and to personal circumstances. That is quite interesting, because we nowadays think that it's normal to think that according to different circumstances, persons have to be punished in different ways, and punishment could be more or less severe. But this kind of legal thinking took place in the second century AD. So that is something that I find particularly interesting. Coming to the second question, so thank you very much. It's a huge question in the sense that I'll try to be very, very quick and just to offer you a brief depiction. So first of all, the servipene, to be servipene, had to be convicted. So they became servipene after the condemnation, after the definitive, the final judgment. Servi pubblici were not necessarily convicted people. They maintain, in some cases, their freedom. I know it's weird, but they maintain that they retain their freedom in some cases. They were paid, and they could fulfill important tasks in the imperial administration, for example, or duties like cleaning streets or something like that. The Servi Cesaris, later known also as Servi Fisci, Servi of the Fiscus, were somehow in the middle, but they were usually not convicted people. That is the point. Still, they were property of the fiscus, whereas the servus pene at the beginning of this long development was not a servus of the fiscus, was not a slave of the fiscus, was not property of the fiscus. The fiscus, you know, if you if you will come to the end of the book, I will try to explain the rather weird position of the servus pene. The servus pene was not completely property of the fiscus, but of course there was an interest of the fiscus on the servus pene, because it was the servus pene was a person convicted, and for example could be a person that worked in the imperial mines, so therefore there was necessarily an interest of the fiscus of the emperor on these servi, but they were not exactly property of the fiscus. And the servifici could become servifici even if they were not convicted people. So as we know, there were many different reasons to become slave in ancient Rome and in general in ancient society, in the Mediterranean societies. And so they could be slave, for example, they were in some slaves were enslaved because they were captivi, so they were prisoners or something like that. So not necessarily convicted people, whereas the servi pene were always convicted people. And the servis pene were in this particular legal situation that was the situation of the condition of the servus nullius, so the servus without any owner. That was property of no one. I know it's quite weird, but it is. This is the reason why I know that Roman jurists had no systematic approach. Well, not at all, but they had no such a huge systematic approach, and systematic is something absolutely modern. But when I think the servi pene and this kind of conception, I find at least an attempt to have a systematic approach to the problem. Ziletti, the scholar, the Italian scholar Ziletti, talked of a dogmatic approach to the problem. That is too much, because talking of dogmatic approach of Roman jurists, it sounds to me not reasonable. But in any case, there is a bit of a systematic approach. Also because the jurists had to put order in this huge amount of new punishments, new procedures, criminal procedures, and so on and so forth. And they had to write down their works and try to find out an order, a kind of, let's say, in nuce, a kind of system of legal punishments, because it was important for the legal effects. A servus pene, for example, could not write down a will, and the will was not effective in that case, whereas a servus publicum could write down a will, just to make an example, and so on and so forth. So servi pene were somehow people detached from the society. That is the idea of of the archaic capital punishment, detaching, so eliminating a person from the society, from the community. That's I would say that this is a very brief and imprecise summary of the problem.
Thank you very much. I wouldn't agree with you. It was not unprecise. It was very precise, but this topic is very problematic. And thank you once again for very clear explanation and brief, of course. Thank you.
You're welcome.
Thank you. Now we have a question from Professor Simic. After that, Professor Polojac, and then Vladimir. Profesor, izvolite.
I cannot hear.
Mikrofon nije uključen.
Thank you, Nina. I hope you can hear me now. Thank you, Nina. Good evening to everybody, and of course to you, dear colleague. I congratulate you on this presentation, and I have a question. Namely, the person excommunicated, which meant that everybody was allowed to kill such a person or to mistreat her in any way, in this case had not to fear the reaction of public persecution. However, they had to fear the vengeance of the relatives. Are you aware, because I'm not aware of this, are you aware of any measures to prevent this kind of vengeance against the person who performed a punishment according to legal system? Thank you.
Thank you very much, Professor, for your question. You mean to prevent vengeance against the person, the relatives who killed the homosacer?
Yes, because the person who killed somebody who was proclaimed homosacer, he had to be afraid of the relatives, so that because not all people were, sometimes they had to take measure to protect.
No, he had not to fear the vengeance of anyone else, because anyone was legitimized to kill the homosacer. So the Rex, and then they recognized the legitimation to kill the homosacer, because the homosacer was impure, and so if he came back to the community, within the community, the community was somehow.
I understand that this was. I understand this was meant officially, but of course not all relatives were satisfied with this. So you see, so whether there are any, are you aware, because I'm not aware, are you aware of any means how the state, the community would prevent this kind of vengeance? This is something that
I'm not aware of that. So first of all, I would like to stress the fact that I'm not a huge expert of Sacertas, because this is a topic on which many scholars have written rivers of so huge works and many articles, and so this is not one of my principal topics of investigation. But in any case, the sources I have had a look at did not mention any kind of this means, so I'm not aware of that.
Because there are people who explain the performance of punishment, but the whole community as a mean to prevent the vengeance of the person who was executed. So.
Social control in this sense, of course. Yes. Social control. It was always a way to control, of course, any kind of vengeance and reaction. But yes, apart from social control, I mean, I'm not aware of any other means.
All right. Thank you.
You're welcome.
Thank you, Professor Polojac.
Thank you very much. This was very interesting lecture. I would like to give one comment. I think it would be very interesting to hear also which crimes, the list of crimes which were punished in different ways. I mean, from this, you mentioned the different kinds of capital punishment. But I think it's a very big topic, and then we will have another another lecture for that, but maybe you can give a few examples. Another small question, because I noticed in this text of Callistratus, this was a text B.
Yes.
One small distinction, because he mentioned deportatio ad insulam as capital punishment, and later on relegatio to ad insulam, which is not a capital punishment. So this distinction would be interesting, and also little observation. For example, I noticed in some texts of this Libri Terribiles, for example, in case of sacrilegium, there is always alternative. For example, to be condemned ad metallum or ad insulam, so exile to an island,
Yeah.
or so this alternative. So please, these are my questions.
Yeah.
And
okay, thank you very much. So I begin with the last one. These alternative usually worked on account of the social status of the convicted person. So even before the emerging of the distinction, the dichotomy honestiores, humiliores, even before, the Romans used to punish in a harsher way the people of a lower status, social status, than the people from high class status, so from the elite. And the main distinction is exactly the distinction you pointed out before, that is the distinction between, or better, the alternative between the metalla for people of lower social status and the deportatio for people of the elite, belonging to the elite. Because in this case, people belonging to the elite lost citizenship, but not freedom. They were not servi pene. They could somehow hope at some point to receive indulgencia from the princeps or something like that, and to come back to a sort of life that was similar to their previous lives. Not exactly the same, but similar. Even though, of course, they were infamous, so they suffered many bad legal consequences because of the condemnation. Whereas the damnatio ad metalla was usually led to the people, the humiliores, so to the people of the lower social classes, and it was a harsher condemnation. Therefore, it was led to them. And a very weird thing is that the same slaves could be condemned to the damnatio ad metalla, and they became servi pene. But of course, the slaves could not lose their freedom because they had no freedom at all. This is what I mean when I say that there is a sort of conceptual construction behind the servitus pene at times. But yeah, the alternative usually depended on the social status of the convicted person. The second question, sorry, was I didn't
relegatio
sorry,
in
yeah.
deportatio, yes.
Yeah, the relegatio and the deportatio were conceived as different condemnations, because the deportatio was harsher and was conceived as a sort of evolution, development of the aquae tigni interdictio. So the deportatio led to the loss of citizenship. Therefore, Callistratus groups the deportatio and the capital punishments. Whereas the relegatio, that originally developed under the reign of Augustus, of course, because Augustus sentenced his daughter Julia to relegatio in insulam. The relegatio was a punishment that did not lead to the loss of citizenship. This is the main difference, and well, then there was let's say a concrete difference consistent in the choice in the place where the convicted had to stay. Usually the relegatio was in Insulam, but the island was not necessarily so far away from the Italian peninsula or from the city, from another part of the empire, and it was an island like Ventotene was for Julia, for the daughter of Augustus. So it was peninsula. It was, of course, a place that was not as pleasant as Rome, but whereas Deportatio could be, for example, in an island, but in that case, absolutely far away. It was impossible to escape. Usually almost impossible to escape from this island, or for example in the desert, so in the middle of the desert. So it was really the convicted was really detached from the community, so it was harsher, and it led, deportatio was harsher, and it led to the loss of citizenship. Therefore, it is a capital punishment. There is this distinction. It's weird, actually. It seems to me weird as well, but there is this distinction. In criminal law, Romans made a lot of this kind of distinctions. It is very interesting to study. This is the reason why I think we have still a lot of material that could be, a lot of stuff that could be studied in order to understand more in depth these topics. The other question concerning the crimes. Yeah, as you said before, we could devote a couple of lectures more to this topic, because the problem is that the same crime developed over the time. So the case that could be punished could be described differently according to the different times, and in any case, the same crime could be punished in different ways at different stages of the evolution of the empire. So, for example, Maiestas was usually punished with metalla or with summa supplicia in the case of humiliores, whereas the honestiores could be punished only with the deportatio. In case of Maiestas, so there were some others. For example, the adulterium was punished by Augustus with the relegatio at the beginning. That was, of course, less harsh than the deportatio. Then we find cases of pirates punished by inflicting them the metalla. There's many other cases. So the abigeatus, so the abigeatus, that is the robbery of cattle, the cattle robbery. I don't remember. Furto di bestiame. That is to say, yeah, the abigeatus was punished with a very harsh punishment, because usually it was punished by inflicting the condemnation of metalla, but in some cases we can read from a rescript by Hadrian quoted in Collatio 11.7.1.4, Collatio 11.7.1.4, in the Collatio Legum. Abigeatus could be punished by inflicting the damnatio ad gladium, so to fight as a gladiator, and in case the gladiator did not die during these combats, he would have been beheaded in 1 year from the judgment. So abigeatus was, it represents a problem, actually a problem in many provinces of the empire. So, and so on and so forth. But we have really, so the situation was a situation in theory, and so the punishments changed from time to time for the same crime. The punishments for the same crime change from time to time.
Thank you very much.
Welcome.
Thank you. Vladimir had a question.
Hvala vam, profesorice Nina. Imam 2 pitanja za profesora Tomasa.
He must in Serbian, I'll translate.
Prvo pitanje je kakva je politika kažnjavanja u Italiji i kakve su izmene i koliko su česte izmene i dopune krivičnog zakonika Italije u vezi...
Vladimire, to nema nikakve veze sa temom predavanja, čovek je stručnjak za rimsko pravo, ne bavi se...
On je govorio, profesorice, o krivičnim sankcijama.
Da li o krivičnim sankcijama u Starom Rimu? Imate li neko pitanje vezano za to?
Evo imam i za to. Kakve su bile sankcije u Starom Rimu za ubistvo člana porodice?
Dobro. Vladimir is curious to know what were the sanctions like for a murder of a member of one's family in ancient Rome. So was it always the death penalty for such a crime? How was it punished?
No, that kind of crime was called at some point parricidium. There was the ancient rule reported, quoted by Festus, the Grammaticus Festus, that is parricidas esto, and so the person who killed a relative or his son or his mother, his daughter, his father, and so on and so forth, would be punished by inflicting him in archaic Rome. I'm focusing on archaic Rome, by inflicting him the pena cullae. So that is the pena I described before. So the person was put in a bag, in a sack, with some animals. The bag was closed and put into the Tiber, in the river. So this was a kind of punishment for the parricidium, the homicide of a relative or a person of the family. But then later on, there was a kind of laicization, of the punishment, and at some point, the person was simply beheaded. So simply, it was punished by the punishment of beheading. Whereas then there was again an evolution at the time of the Principate. So the punishments changed again over the centuries. But at the beginning, likely the punishment was likely the pena cullae, so the punishment of the sack, of the bag.
Thank you. Vladimir, I hope you understood. If there are any issues, I'll help you afterwards. If nobody else has any questions, I'd have a small one. I am sorry if it's an inappropriate question, since Roman law isn't my main area of expertise, but I am curious, since we know that in archaic Rome there was the rule that a Roman cannot become a slave in Rome, hence selling people into slavery trans Tiberim. But later in the Principate, we have punishments that include the loss of liberty. So is there any data in the sources regarding how this was changed? Maybe someone who criticizes anything of the kind?
No. So we know that there were some exceptional cases of still Roman citizens that could be enslaved still at the end of the Republic. Usually connected to the military duties of the Roman citizens. There were some cases in which Romans could be enslaved. Then the situation developed in a different way at the time of the Principatus, but we don't have so many information sources and data concerning this change, because actually we don't have so many information and data and sources concerning the birth, the creation of the Servitus Pene, so how it began to develop this legal institution. So this passage is still a bit obscure, and so we don't have so many information about the topic that you mentioned, unfortunately.
Thank you.
You're welcome.
Any more questions? If not, I would like to thank Professor Beggio once again for a very interesting
Thank you very
lecture. I
much.
think the length of the discussion testifies well how much the audience liked it, and hopefully you will be our guest once again in the future live in Belgrade.
With great pleasure, of course. Thank you very much. Thank you. It was an honor for me to be here, and so thank you very much, and thank you for your patience.
And just to announce our next meeting, unfortunately in Serbian, so you probably won't be interested in attending, but we're going to have a book promotion, a promotion of the Serbian edition of Chris Wickham's book, The Heritage of Rome, which concerns the history of Europe in the early Middle Ages. And that is going to be held in hybrid format, so we're going to have it at the faculty live, plus the WebEx transmission, so you're welcome to attend in whichever way you prefer. Thank you once again for your attention, and have a good
Thank
night
you.
and a good weekend.
Thank you. Thank you very much. Thank you. Thank you. Good evening.
Bye.
Bye.
Goodbye.